got notes. I have a note taker. I had a note taker like all through college and law school. I got like all the worksheets they had filled in just in case I missed something. The one thing they didn't do though was accommodate my tests, so they'd give everything to me ahead of time, and I'd go somewhere else to take it in a private room and then just turn it in. But that wasn't a big deal.
Actually, I found getting my accommodations through Barbary incredibly easier compared to getting accommodations from the bar. Yeah. It's a slam dunk. Barbary definitely knows their obligations under Title III. But
they were sued.
Oh, that helps. Yeah.
But at the same time, I was denied the request of my assistive listening device, and the reason they did that was because I decided I was going to do a live lecture, so it would be easier for me to lip read. I did get my preferential seating, and I was in a conference room with maybe 500 people. And because it was in a room of 500 people, they had a sound system set up. And they said, well, if we already have a professor speaking through a microphone at the front, you are being accommodated in that you get your seating, you have a captioner there with you every day, and you're being given the filled-in notes. So that's actually one request we're going to deny. And so it kind of made sense, but still, because I'm someone who relies a great deal on the residual hearing I have left, it really helps me to kind of put things in context throughout the lecture that the presenter is giving, because you have a 3 to 4 hour long lecture in your Barbary class. And the professor is going to make jokes or is going to say other things that put those rules into context or that make the material make sense to you. And if you are without that, I mean, for any of you who are reading all of this wonderful screenplay that's going on over here, it's kind of hard to put the feelings or put the emotion into that. And that is one thing that I rely on in terms of being able to comprehend material as well. So it was a little frustrating for me, but because I had the filled-in notes and because I had the captions, I was still able to get the material and for the most part be able to understand it.
Okay, great. Jason, and then in the back, and then we'll come back to the front.
Yes. Did you actually talk to Barbary individually, or how did you handle talking to Barbary about either MPRE or bar accommodations?
Well, it's for the review course. Mm-hmm. It's for Barbary. Every person has to talk individually. A lot of the answers to the questions here that we'll get to, it depends.
And let me just say, they have a process that's published on their website.
Okay.
So follow the procedures, which a lot of students aren't aware of, because of course you have to scroll down through all their information to find it, but the process is there, and you actually make a written request, and you need to get documentation from your school about what accommodations that you actually receive in law school.
Which is great, because actually you're going to get that from the school anyway. When you're applying for your bar accommodations, you don't have to necessarily get something separate so much. Well, I guess you want to say note-taking or whatever the extra accommodations are.
Right, because for the bar, yeah, you want it separate because you want all of your classroom accommodations included in the Barbary or for the bar review course, which you might not necessarily appear in your actual bar exam accommodations.
If I can just add one thing to that, I actually had individuals from Barbary calling me to work out my accommodations process. So I found them to be much more personable than, of course, the bar exam and the MPRE.
Great, yes.
So my question is not about accommodations per se, but about being permitted to take the bar in the first place. My understanding is that most, if not all, states ask about history of mental illness. And I was just wondering what kind of impact that would have and what advice you have for someone who has had a history of mental illness.
I can answer as it relates to California, and maybe there might be someone else in the room can answer as it relates to other states, but in California the question is actually, do you have a mental illness that will impact on your ability to practice law? And so it's a current question. And that's the question. Now, if you're asking about needing accommodations based on, which some people do, and there are plenty of students who actually receive exam accommodations who have a mental illness or a psychological disorder. But that's just a part of this other process. And there are forms for that and everything. But that's not your question, is that my understanding?
No, it's not about accommodations.
Yes.
Claudia actually can say a little bit about that.
Yeah, I mean, I'm an attorney, and a number of advocates are sort of tracking this issue in all 50 states. So it is state by state, but what we think is the only lawful question, although we actually wish they didn't ask it at all, but the only lawful question is, are you currently unable to practice law with or without accommodations? So that's what we would say, and so we help people answer that question. You know, so there are attorneys that you can consult with about how to answer that question. Just stay in touch with this network, which is so great for this
And
network.
NALSWD has on our website a 50-state survey of what the current questions are, so you can check that resources.
Oh, that's great. I didn't think I'd catch that. That's really awesome.
Oh, just a quick note. I teach professional responsibility, and among other things, and I was in Oklahoma, and they have a very restrictive question. They have a list of mental health concerns that concern them the most, and it's an odd list. And there's some things on there that you're like, why is that an issue? I think at some point there were eating disorders on there as well. I mean, you're just kind of not sure where they got their list from. It's not all of the DSM, it's some of it, and you're not sure where it arose from it. We brought in their attorney that does the investigation. So if you were to flag that, if you're like, yes, I'm on your list. And he said what's most compelling to him is if you say, yes, I have bipolar disorder, but you show that it's been an issue in my life, but every time it's come up, I've tried to get treatment, or I've responded in an appropriate way. And they're interested in how you're going to respond if you have a client, or you can leave a client hanging. And you know, because we have enough issues in our bar that have to do with substance abuse that are not, you know, in the DSM. So he said, you know, they had someone with schizophrenia who was in and out of the hospital every year, but the fact that she documented all of that, said, you know, I take care of myself. This is an issue for me, but this will not be an issue for my clients, was fine. And there was not any condition based on that. So it depends, but it should be asking that question anyway.
Good to know.
Corey?
Yes, my question is, you know, I have hearing impairment, and more recently it's been documented, like, when I was a kid, I got tested, and I did have a hearing impairment. They said I didn't require hearing aids, and it got progressively worse. And it wasn't until recently, like my second year of law school, that I took action and, you know, went back to the doctor, and they saw it was worse and I needed hearing aids. Do you think that the Bar Association, when I apply for accommodations, they're going to look at the history and say, well, you know, you've gotten along most of your life without any accommodations that you don't need it?
Well, I think that the bar actually, most recently in your case, what the court actually said about that issue was that hers was a degenerative vision impairment that got worse, and of course that had to be, her current condition is what mattered. And so I think that would actually apply in your situation as well. I mean, you have the history and the degenerative and its current.
If you have many audiological reports or audiographs, submit each and every single one of them so you can demonstrate that it is progressively getting worse.
I'll see if I can track it down. You know, I graduate this year with the time. I'm not sure if I can go back, but I mean, I've taken several tests along the year, and hopefully I can get some documentation about it. Thank you.
Yeah, I've actually a very related question. I have a condition that developed post-undergraduate, so I have a strong, it sounds horrible to phrase it this way, but I have a strong record of achievement without getting accommodations. Now I'm in law school, I get accommodations, and it's tremendously helpful. It sounds like almost that will be something that the examiners will just hang their hat on and say, we can't give you accommodations.
It's a red flag, but I've had numbers of students with all kinds of conditions that have developed or disorders that have developed. And you have to realize that kind of in your like post-undergrad and like early to mid-20s, a lot of medical conditions actually develop for people during that time. So it's not that unusual, especially given the expanded definitions under the ADA. So a lot of autoimmune disorders, mental health. I had a student, and a lot of those of you who are active or were active, a lot of head injuries. You know, due to snowboarding and accidents and other things. So I've had a lot of students with very successful undergraduate records who then developed, you know, conditions, but well-documented history, objective evidence, impact on you specifically, academically, and in testing, and that's what seems to be required.